as the National Shooting Sports Foundation files a request to add to their filing challenging the state's gun manufacturer liability law, saying, hey, look, the U.S. Supreme Court tossed out a case where Mexico is challenging gun manufacturers, so this case should also be tossed. Well, the state of Illinois responding to that motion. We'll get to that here with Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and wake up with us each and every weekday morning, bringing you the latest here on YouTube with the Center Square. So we've been tracking litigation against gun control efforts in the state of Illinois, and I don't think that there's going to be any slowdown of that, especially as you've got the Southern District of Illinois gun ban challenge that is now in the appeals court on final judgment after a district judge said that the gun ban was unconstitutional, and even the U.S. Department of Justice filing on behalf of the plaintiffs in the appeals court saying that the gun ban is unconstitutional and pointing to all the recent U.S. Supreme Court stuff that the appeals court got wrong and that other courts across the country are getting wrong, they allege. So we've got that case that's still working through, and the state's going to be responding to the plaintiffs come 4 days from now. So July 28th, we should have that filing. We'll definitely unpack that here with Illinois in Focus Daily. We've also been tracking the Schoenthal case. That case is still pending a decision from the appeals courts. That's the challenge against Illinois' prohibition of carrying concealed firearms on mass transit. So that's in the appeals court after having public hearings, and they are going to have a decision soon. When courts move at their own pace, we'll keep you posted. But you've got this other case that's been matriculating for almost 2 years now, and that's the case challenging Illinois' gun manufacturer liability law. And the latest filings in that case we're going to go through here. But if you go to thecentersquare.com, you'll be able to find some of these in the archives. And again, this is all free. We don't charge you to go and check this out, so you can actually see this for yourself. But this is from April of 2023. Illinois firearms industry vulnerable to lawsuits under new law. And this, again, back in April of 2023, it was House Bill 218. Governor Pritzker signed that on the heels of the Illinois Supreme Court upholding the state's gun ban. He said that we hold opioid manufacturers accountable, vaping companies accountable, predatory lenders accountable. Gun manufacturers shouldn't get to hide from the law, and now they won't be able to. Here's to an Illinois where everyone feels safe in every corner of our great state. So he went ahead and signed that measure. This is one of the questions of how does this interact with federal law? You've got federal laws that essentially say you can't have lawsuits against, firearms industry for liability issues, and you even had that case coming through the U.S. Supreme Court that dealt with this as well. But after the governor signed that, you did have a lawsuit that was filed rather rapidly. So federal law or federal judge was assigned to the lawsuit in the firearms liability law. Again, House Bill 218 passed in April of 2023. But here we are. We've got the latest twists and turns, and we're going to go through some of these filings as we make it through the National Shooting Sports Foundation's lawsuit against the state's gun manufacturer liability law, allowing for people to sue gun manufacturers for third party and how they use it. So earlier this month, June 10th, there was a motion to file a supplemental authority. Now, what the supplemental authority is by the plaintiffs is they say, hey, there's this other ruling from a different courts that directly affects what we're doing here. So they wanted to put in the Smith & Wesson versus the government of Mexico, essentially, Estados Unidos Mexicanos. And that was the U.S. Supreme Court that ultimately sided with the gun manufacturers there just a handful of weeks ago. Then the following day, you have an order granting the motion for that supplemental authority. So the judge in the Northern District Federal Courts handling this case from the National Shooting Sports Foundation, Judge Stacey Yandel, went ahead and said that the authority to file that supplemental filing is granted. So it's been filed. But we have a response here with the motion to leave to essentially deny that. So let's go through these two documents here. All right. So we'll first look at the National Shooting Sports Foundation's filing to have this supplemental authority. It says that August 14th, they allege that House Bill 218 authorizes state action to the Protection of Lawful Commerce Act. Then you had plaintiffs file a preliminary injunction for that. Defendants filed opposition. Then June 5th, fast forward all the way to 2025, the U.S. Supreme Court issued a decision in Smith & Wesson Brands versus Estados Unidos Mexicanos. A copy of that opinion is attached. Smith & Wesson, the Mexican government, sued 7 American firearms manufacturers, alleging that they failed to exercise reasonable care to prevent trafficking of their guns into Mexico and are responsible for harms arising from the weapons misuse. 2 of Mexico's theories are directly relevant here. First, Mexico claimed the manufacturers had failed to impose the kind of controls of their distribution networks that would prevent illegal sales to Mexican traffickers. According to Mexico, the manufacturers needed to implement processes for monitoring or supervising their dealers' sales practices so as to minimize illegal sales or to traffickers. The Supreme Court rejected that theory. The problem with the theory was not, as with some other components of Mexico's allegations, that Mexico had not pleaded enough. The court was clear that the complaint alleges with sufficient plausibility that the manufacturers could do more than they do to figure out who those rogue dealers are and then to cut off their gun supply. The problem was with that theory itself. The PLACA prohibits efforts to hold manufacturers of lawful firearms liability under state law just for failing to make unaffiliated retailers follow the law. Yet that theory is indistinguishable from the reasonable controls theory HB 218 in the state statute codifies, under which manufacturers of lawful firearms may be held liable under Illinois law just for failing to implement reasonable procedures, safeguards, and business practices sufficient, among other things, prevents the sale of distribution of a firearm-related product to a straw purchaser or a person prohibited by law from possessing a firearm. Second, Mexico alleged the manufacturers made design and market decisions intended to stimulate cartel members' demand for their products. Mexico claimed the manufacturer's product of AR-15 rifles, AK-47 rifles, and 50 caliber sniper rifles, coupled with the marketing of those products in ways that make them attractive to criminals, contribute to a public nuisance south of the border. The Supreme Court rejected that theory in no uncertain terms because, quote, those products are both widely legal and bought by many ordinary consumers. Manufacturers cannot be charged with assisting in criminal acts just because Mexican cartel members like those guns too. Put differently, manufacturers cannot be held liable under state law just because they design and market lawful firearms and other legal products that criminals like. Once again, however, HB 218 in state law of Illinois codifies an indistinguishable theory. Plaintiffs respectfully request the court enter an order granting plaintiffs leave to file notice, and they were granted that. But let's take a look at what the state responded with. 3-page filing here. This was filed yesterday by the Illinois Attorney General, Kwame Raoul. And it goes on to say that National Shooting Sports Foundation's motion offered notice to the U.S. Supreme Court's recent decision, Smith & Wesson Brands versus Estados Unidos Mexicanos, arguing that it supports holding that Illinois' Firearm Industry Responsibility Act is invalid on its face. Raoul's office says it does not. Instead, Smith & Wesson's posture and facts are wholly inappropriate and deliver no support to the NSSF's novel effort to use the Protection of Lawful Commerce in Arms Act to invalidate the Firearm Industry Responsibility Act from Illinois. Raoul's filing says in Smith & Wesson, the government of Mexico named 7 firearm industry members as defendants in a lawsuit. The defendants asserted PLACA has a defense in that suit, and the court had to determine whether the action fell within one of PLACA's exceptions. The application of PLACA was properly litigated in the suit, as by its own terms, PLACA may be invoked when an industry member faces a qualified civil liability action in court. Here, by contrast, not a single NSSF member faces a qualified civil liability action filed by the Attorney General. Rather, NSSF attempts to turn PLACA on its head, using it as an offensive weapon to strike down an entire state statute, even prior to any state enforcement of the statute. Smith & Wesson did not involve, nor did it provide any support for such an unconventional use of PLACA. Furthermore, the court's holding in Smith & Wesson was straightforward and inapplicable to this case, Raul's office said. Specifically, the court concluded that while PLACA's predicate exception, it permits a suit to be brought against a gun manufacturer that has aided and abetted a firearms violation and in doing so proximately caused the plaintiff's harm, the plaintiff in the case did not plausibly allege such aiding and abetting. This holding has no bearing on this case, Raul said, which does not involve any allegations of aiding and abetting under PLACA's predicate exception. For these reasons, while the court should take notice of Smith & Wesson as an example of a defensive assertion of PLACA, the court should disregard NSSF's supplemental argument seeking to apply the holding of Smith & Wesson to this action. So that's the back and forth over how the Smith & Wesson v. Mexico case may impact the challenge that NSSF has against Illinois' firearm liability law. And again, this case was filed in April of 2023. Here we are 2 years after the fact, and we're still dealing with briefs, and this is all in the district court. This is not in the appeals court. And when you've got the state saying that nobody's been held liable under the state's firearm liability law, you do have in Cook County, the city of Chicago suing Glock, and I believe that case is still ongoing as well. However, I'm sure that some attorneys may be considering, if they haven't already, taking the U.S. Supreme Court case and filing a supplemental authority in that Cook County state-level case. So there's a lot to watch there, but that's the latest on the challenge against Illinois' firearm liability law with that filing that was made by Attorney General Kwame Raul yesterday. I've been looking at the dockets for other cases, and we'll keep you posted. Again, the cases challenging the state's gun ban still ongoing, especially in the 7th Circuit U.S. Court of Appeals, as you've got the plaintiffs filing, and now the state has to reply as they're trying to defend the law after a district judge said, we've got a strong record here to show that the law is unconstitutional. Could that gun ban challenge be the next to go to the U.S. Supreme Court? We'll be watching. All right, it's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Wake up with us each and every weekday morning here for more Illinois in Focus Daily.